Assalamualaikum Dr. Ain. My name is Nawal Najiha and I'm going to present the introduction of patent and related case law. Patent law grants inventors exclusive right to their innovations, encouraging innovation and technology sharing. Key cases like Alice Corp versus CLS Bank and Mayo versus Prometheus set standards for assessing patent eligibility. Fact of Alice Corp versus CLS Bank International case is Alice Corp owned patents for a computerized system to facilitate financial transactions, specifically reducing settlement risk in currency trading.
The issue of Alice Corp vs. Bank International, the Supreme Court decision in Alice Corp vs. CLC Bank International 2014, referring patent eligibility for software and business method under 25 U.S.C. 101. The court applied two-part test from Mayo, finding the patent covered the abstract on idea, like the inventor's concept to make patentable, merely implicitly an abstract idea on the computer was infancy. This line made ruling registered patent ability for invention automatically traditional process without significant technological advancement. Its higher security of software and business method patent represent the standard provided they are validated in patent innovation to related industries.
Assalamualaikum and good evening to everyone. My name is Muhammad Hardianan and I'm going to talk about case 2, which is between Mayon Collaborative Services versus Prometheus Laboratories Incorporated 2012. This case was a US Supreme Court case addressing the patentability of medical diagnostic method. Prometheus patents a process for adjusting drug dosage based on blood metabolite levels. The court invalidated the patent, ruling there merely described a natural law correlation between metabolite levels and drug efficacy, without sufficient inventive application, making them unpatentability under Section 101 of the Patent Act. Next, I'm gonna talk about the fact of this case, which is Prometheus Laboratories held patent for a method to optimize drug dosage by measuring blood metabolite levels to evaluate toxicity or effectiveness. When Mayo Clinic used similar method, Prometheus sued for patent infringement. Mayo argued the patent were invalid, claiming they covered a natural law, the correlation between metabolite levels and health outcome, rather than a patentable invention.
My name is Fatina Ziha binti Imran. I want to talk about the issue and the decision. The main issue was whether Prometheus patents, which were based on this natural biological relationship, could be protected under Section 101 of the Patent Act. Could a process based on something natural be patent? So, the Supreme Court decision ruled that Prometheus patents were invalid. They decide that natural laws like the link between metabolic levels and health outcomes cannot be patented. The steps in the process were considered basic and routine, not creative or new enough to qualify as invention. Therefore, the patents did not meet the requirements for patentability.
My name is Nur Amira Shahira and I would like to present about the case law of Festo Corporation versus Soketshu Kinzoku Kyogo Kabushiki Corporation 2002. The fact of the case law is, first, parties involved. Festo Corp accused SMC of infringing on its patent for a valve assembly used in pneumatic system. Second, patent claim. The dispute focused on specific airflow control method essential for industrial machinery claimed by Festo Corp as unique to its patent. Third, SMC defend. SMC argue their valve product were distinct and did not infringe upon Festo Corp patent.
Regarding to the case, there is a two main point that I would like to explain about. Briefly, there's 2 points that have been stated. The 2 point about the case law is about the issues, which is the second point, and the third point is about decisions of the court. When we stated about the issue part, is where they stated that whether Festo claim an amendment surrender its right to argue that SMC's product was equivalent to the original and patent invention. where this is what they mainly stated in the issue part. When we see about the decisions of the court, it's where they had been defined and also explained that the court ruled that whether patent narrowed their claims during the patent application process. This process is where there is a presumption that they have surrendered for the amendment elements. That's what they stated and defined in the decisions of the court. That's all from me. Thank you.
The case law about Novartis AG v Union of India 2013. The Novartis AG v Union of India 2013 decision is a wattage movement in Indian patent law addressing the balance between intellectual property rights and public health. So next, I'm going to talk about the facts of this case, which is Novartis filed a patent for Gleevec in 1998, but it was opposed and rejected under Section 3D of the Indian Patent Act for lacking proof and hence therapeutic efficiency. Thank you.
A very good morning to Dr. Ain. Today I'm going to talk about the issues and the decision by the court of the case Novartis AG v Union of India in 2013. The key issue was whether the beta-crystalline form of imatinib mesylate demonstrated sufficient therapeutic efficiency to qualify as a patentable invention under Section 3D. Essentially, the core legal issues as contended with the case of Novartis revolve around several thorny issues which concern the trademark legal framework within India and its public health of that domain. The decision by the court was the Supreme Court rejected the patent. This emphasized that therapeutic efficacy is essential for patentability, ensuring affordable access to life-saving drugs. Thank you.
Mrs. Adam, I would like to tell about case 5, Pfizer Inc. versus Dr. Reddy Laboratories Ltd. 2007. For introduction, Pfizer Inc. versus Dr. Reddy Laboratories Ltd. decided in 2007 is one of the landmark decisions in pharmaceutical patent law. It revolves around Pfizer patent of amyloidine mesylate, an active ingredient in the blood pressure drug Novas, and Dr. Reddy challenged to the validity of said patent through an ANDA under with paragraph IV certification. The court held Pfizer patent invalid for obviousness and thus devoid of invention, permitting Dr. Reddy to market a generic. The case is another example of the balance between protection for innovation via patent and affordable access to medicine drug competition in generic drug. For fact, Pfizer had a patent on a non-blood pressure drug called Novas. Dr. Reddy wanted to sell a generic version at a much lower price and thus argued that Pfizer patent was invalid because it was not novel.
Hello, my name is Fakir. The issue is about whether Pfizer patent for a drug was legally valid. For Dr. Reddy to sell a generic version, they would need to argue that Pfizer patent was not unique or original. If they can prove this, the patent could be invalidated, allowing Dr. Reddy to sell their version legally. It all boils down to whether the patent drug truly meet the criteria of being a novel inventive under patent law. The court decided that Pfizer patent was not valid because the drug was considered obvious. This cleared the way for Dr. Reddy to produce a cheaper generic version, making the medication more affordable for people. Thank you.
For the conclusion, the highlighted cases illustrate the evolving global legal landscape surrounding patents, emphasizing the balance between technology innovation, intellectual property rights, public health needs, and the challenges of enforcing patent laws across diverse jurisdictions.